Okay. So here we are. Welcome everybody. It's great to be back here at the University of Ferrara, Department of Law. I've been away from some time, but the first semester has eventually begun, and with the first semester, also the meeting and the seminars organized by the chair of taxation and international tax law here at the department. Um, the kickoff today will be with Rizella Ramacho Calvino, as a professor at the University of Zululand in South Africa. I think that the University of Ferrara has signed a memorandum of understanding like a couple of years ago, last year, 2 years ago, with the University of Zululand. We have been working together intensively in the last month. We have published, an article. I would say it's a nice article, but I can't say that because I'm one of the author. But it has been published on Intertax. It has been appreciated by the community of tax lawyers and tax scholars in Europe very much so far, on the idea of solidarity, on the idea, on the principles developed by the South African academics in the field of taxation, in the field of wealth, in the field of solidarity, and so on. But today, our focus, our attention will be, well, of course, on South Africa, because Professor Calvino teaches over there. But I think today we will concentrate our attention on family, on the idea of family, on the wealth of the families, on the ways and the means available under the law. So private law, family law, but also, of course, tax law, in order to preserve, to protect family wealth, to grant to children and to heirs the best future possible. Um, and together with Professor Calvino, Alessandro Casanova shall provide at the very end of the main presentation a view of the Italian tax system, of the Italian family law in the matter. I would say that Italy is quite advanced in this respect. Italy, just in order to open the floor to the presentation, the discussion. Well, Italy is a single law country, it's not a common law. South Africa, I think, is mixed. Am I correct? Mostly common, but hybrid, yeah. Yeah, exactly. So we know we use, well, legal instruments such as trusts, such as foundations and the like. But some years ago, I think it was 2015 or 16, I don't remember exactly, but Italy has introduced a special legal instrument to protect family wealth in case of children with disabilities. We call it, well, this vehicle is called the so-called After Us, and it is intended to protect as much as possible family wealth when a situation like that occurs within a family. So a children that has special needs that are addressed by parents, so father and mother, as long as they are alive, of course, but, as time passes and parents grow old, they probably then are not able any longer to provide the children the kind of services they are in need of. And so this system, this vehicle is called After Us because it's intended to provide to children the same level, the same quality life that he or she enjoyed earlier. And of course, the structure, the legal measures that Italy has introduced are fiscal by design. So tax exemptions, tax incentives, tax waivers to these wealth attributed, separated for the children needs in this respect. But this is the result. This is just an example. I believe that a lot depends on the understanding of family in the different legal system, understanding of the relationship within the couple, the relationship between the parents and the children, and so on. So yeah, although our priority is in the area of taxation, Of course, we cannot, but we have to become a little more familiar also with family law, private law of the country we are approaching to. So in the case of South Africa, and I mean, I believe that even if South Africa is far away in geographical terms, thousands of miles away from Italy, well, the connection between your country and ours are very strong. Not only because of your surname, but also because of a lot of Italians moved to South Africa. The economic interactions between the two countries are remarkable in these days. Yeah, both our countries, let's say, are experiencing a moment, well, not so easy, both there and here, but we are doing our best to overtake all the challenges and all the problems, all the difficulties. And I think that when we face challenges, when we face, well, problems, looking at families, looking at couples, looking at family law is of paramount importance, and taxation it can be a great help in that respect. As everybody knows, I'm not that good at making introduction, but I keep them short as possible. So I really stop here. Thank you, Lizelle, for being with us today. We will have a presentation of, say, I don't know, like maybe half an hour, 20 minutes, 40 minutes. Feel absolutely free. This is Ferrara, so we are absolutely informal. Then we will leave the floor to Alessandro, and then the event will be over. For the people attending from home, my PhD students so far, Francesco Castro and Aniotto, maybe others will join later. I will try and share the PowerPoint that Lizelle has, Professor Bacicaldino has shared with us. And so Lizelle, the floor is yours. I think if you have problem, the microphone is here, but the quality is very good of the microphone. So if you want to stay there, perfect. If they have problem in hearing you from home, I will just do something in that respect.
Marco, thank you very much for having me. Lovely to meet your postgrad student as well. I have quite a protective voice, so usually my students complain I speak too loud, so I shouldn't be a problem and I should be audible. Yes, most certainly. I think also in terms of what constitutes a family is a very interesting question. In South Africa, and I'll get to my presentation shortly, but just a bit of an introduction. In South Africa, we have obviously Roman Dutch as the basis of our legal system. We have English law influence. What makes South Africa a little bit different, and maybe the difference is also good. You know, I'm a firm believer in if you are pushed out of your boundary, that is the time that you grow. Innovation, it's good. I think it's Roosevelt that said, pushes innovation. And from that perspective, for example, us having the infused system with customary law as well and a constitution as supreme law in South Africa, it basically forces us to look at family from different perspectives. So yes, you have your family, and in the Dutch system, they basically refer to it as the gesin, which is your direct family. And then you have your family, which is your extended family. And then in the Zulu custom, it basically extends even further than that. And even with regards to tax, which we'll touch on shortly, they look at not only transferring wealth in the sense of assets or cattle, in this case. Cattle is a very big form of assets for them. Here it will probably be flour, I believe, here in Ferrara. Flour.
Okay, it's maybe the Netherlands, maybe, who knows?
But they also transfer family responsibility. So in other words, responsibility to look after the family, which is basically hand in hand with what you just discussed, Marco, with regards to looking after the disabled, not necessarily disabled, but extending that responsibility. So I think let's start with the presentation. It is very informal. So I'm just going to give a very brief introduction in terms of family law, just to explain a little bit the South African case as well. The context of our country, like I've indicated, is also a situation where we need to look at wealth inequality. It is one of the highest in the world, I believe. For many families, the question is not just how to accumulate wealth, which is probably the easier of the two, but also how to preserve it across generations. And I think this is the problem that we are facing and the problem that you guys are facing as well. Although I did look at both systems, and I think your tax system is probably more protective than ours currently. So at the same time, we also have the government through taxation that seeks to obviously redistribute the resources and prevent avoidances, which I believe is also something that some said that Italy is grappling with. So there's two goals here. Firstly, protecting family assets, and then secondly, ensuring compliance with public policy and create that's the tension that it creates. So just moving on with regards to the slide. So Marco, you are running my slideshow for me, so thank you so much for that. Just very briefly, we run a Roman Dutch common law statutory system, which overlays aspects like tax law, customary law, which coexist and all within the constitutional framework. So like I've indicated before, Roman Dutch is the basic, the common law foundation. We have specific statutory regulation in terms of tax as well as succession, interstate and state succession. And then in addition to that, we have to also include the customary law principles. And under all of this, the umbrella that overlooks all of this is obviously the Constitution. And the Constitution has in the past already made certain contributions as far as the interpretation of succession is concerned in the customary realm as well as the common law realm. So today, basically, we're going to be looking at threefold. Firstly, I thought let me give you a quick introduction, outline of the tax framework impacting family wealth. Secondly, to explore political tools or practical tools rather for protecting, including trusts and wills. And then thirdly, to examine key case law, some very relevant, hot off the press as far as disputes, illustrating the practical from family generational wealth. So if we can move to the second slide, Marco, quickly the roadmap. I'm just going to briefly touch on that. We start with the tax principle, covering estate duty, donation tax, and capital gains tax. Those are the three main tax aspects that we have to touch on. We look at succession in South Africa. We then also examine customary law, focusing on succession and how reforms have reshaped family wealth distribution. We also look at common law tools such as trusts, like you have as well at wills, which then provides flexibility and protection. And then lastly, also obviously compliance and governance, reflecting on the South African Revenue Services, Masters Office, etc. So moving on into slide number 3. I just would like to give a small disclosure at this stage.
Just one, right?
Yeah, 100%. But just please note that that I do not intend to delve into every technical tax formula or calculation like my very experienced colleague here and probably his postgrad student as well. Instead, my focus is simply just on the principles, some real life examples as well as legal reasoning that you can apply in practice. So South Africa, like we indicated, is a mixed legal system. I think in your terms we refer to it as a tiramisu. It's more like a tapestry. So you have the foundation of the Roman Dutch common law.
Multi-layer.
The multi-layer, with a nice multi-layers. We had some last night, which inform the contracts, the trusts, and the wills. And then on top, you have the statutory law, which is basically your tax legislation, your pension, your company law, which basically then governs your economical transactions and impose obligations on families and the state. And then that is then layered on. This is the customary law system, which regulates family and succession matters for communities that observe traditional practices, including, and this is very important, polygamous marriages, which is something that's taboo in Italy as far as I'm concerned.
But it's admitted in the customary.
Yes, it's recognized in South Africa.
Wow.
Yes, there's a lot of scope in that, Marco, but that's another paper for discussion maybe.
Yeah,
so the Constitutional sits at the ultimate referee, ensuring then the dignity and equality and build, and it does not erase culture. For instance, in polygamous estates, tax obligations must be met, yet succession may still reflect the practices, and then planners must obviously navigate these overlapping legal regimes carefully. So you can see, dealing with this tiramisu, like with any tiramisu, there are layers to it, and to be a tax consultant, which basically try and organize wealth and to protect wealth transformation or transgender bestowal, it's quite complex. You need to look at quite a few legislative obligations. So your main statutory regulation, slide number 4, Marco, basically then deals with estate duty. So estate duty was introduced in 1955 in South Africa, and it relates to taxes and transfer of assets at death. So the rates are 20% up to 30 million rand, and thereafter 25% above that. So there's a 3.5 million abatement per person. That is in terms of Section 4A, capital A of the Tax Act, and an ultimate spousal deduction under Section 4Q, allowing spouses to transfer wealth without tax, which is quite a nice perk to have in terms of estate planning. A practical issue, however, arises with liquidity and liquidity of assets. If we consider, for example, a family farm with 20 million rand, with minimal cash, if the executive, for example, then have to raise liquidity to pay estate duty, perhaps by selling part of the farm or borrowing. So poor planning can force asset sales that families never intended. Hence, there's a need for an understanding that interaction between estate duty and liquidity is crucial when you are looking at preserving family wealth. So if you look at a 20 million rand estate value, the farm, minus your 3.5 million abatement, your net estate value that needs to be taxed is 16.5 million. And if you look at 16.5 million at 20%, that brings it to 3.3 million rand. I think I did a calculation on my slides, Marco, with regards to what it is in euros. I'm not sure, but I did put it there somewhere. So looking then at donation tax, that's slide number 6. When we look at donation tax, it exists to prevent lifetime transfer from avoiding estate duty, obviously. These rates mirror equal estate duty. So again, you have your 20% up to 30 million and thereafter 25% thereafter. And this is in terms of Section 54 to 56 of the Income Tax Act. Each taxpayer, again, has an annual exemption of 100,000 rand. And that's in terms of Section 56(1)(c) of the Income Tax Act. And spousal transfers are unlimited. So again, there's an opportunity. And this has, in fact, been the case until Section 7(c) of the Income Tax Act came into operation, which is an anti-avoidance provision that was later on instilled. And that basically deals with low interest or interest-free loans by connected persons, typically your donors to trust. And this then ensures that such loans are deemed donations for donational tax purposes. This prevents taxpayers, in other words, from transferring wealth to trust without triggering donations. For example, if a parent lent 10 million rand to a trust at 0% interest, then SARS says you have to treat it as a taxable donation each year. So families often inadvertently trigger these donation tax, particularly with intra-family loans or transfers. So effective planning, again, requires careful scrutiny and awareness of these provisions.
So, Zen, if I can interrupt you on this point, just to understand if I got it right, you know that in Italy there has been a huge debate on this point. Maybe Alessandro will be more accurate later. The point is the following: when you, let's call it donate, or when you attribute asset to a trust, any kind of, is that a wealth transfer or not? Long story made super short. In Italy, they say, well, no, that's not the case because you are not transferring to somebody else. It's a trust. So, long story made super short, that transfer is not taxable. And the tax is very low, not for sure, not on your 20%. Well, if I got you right, in the South African tax or legal system, each time you transfer your wealth to a trust, well, let's say generically, not special case, but most of the cases, when you transfer wealth to a trust, well, that decision, that deed is taxable, 20%.
Yes, because you must remember the following. A tax is a different juristic person.
Okay.
So you are transferring an asset from one person into a juristic person's possession. So you are no longer owner of that asset. It now belongs to the trust.
Yeah, the trick in Italy is that, well, a trust is not a juristic person, so maybe something in between. It's not an incorporated entity like a company or else. It's not a natural person, but there is some sort of, I mean, we understand that the wealth you have transferred is not yours anymore, any longer.
Yes.
But still is in a kind of limbo in between. So because of that being in between, just wait for charging tax. But there has been a very harsh debate in the matter where dozens of cases from the Supreme Court litigated with.
Because also what people are doing, Marco, to try and avoid tax, is they transfer property into a trust, looking at the tax benefits, which was quite comfortable in the past before change of legislation, but they're still involved with the responsibilities and the running of the trust. So they refer to it as a sham trust. I don't know if you have the same terminology in Italy, a sham trust. So yes, you got assets there for tax purposes, really, but you are still controlling it.
Yeah, we got something similar to that. Yeah, the trust incorporated for yourself, for your purpose trust. Let's
benefit.
call it this way, yeah. And that kind of structures are, well, sham in most of the cases. Yes, indeed. Yes.
Okay, well, let's
But-
go to the next one, is section 7 then. Just to explain quickly, Marco, maybe this will also assist just to maybe clarify if I'm not articulating myself too.
Yeah, this is the answer. Sorry. The answer, yeah, it's there.
Preempting. So basically, if you have a section 7C, for example, loan to a family trust, the scenario was the X gives a family farm or family trust a loan of R1 million. I think I've put some numbers there, have I, Mark?
Not in this slide. Next one, maybe.
The loan is interest-free. So SARS official interest rate is 10% per annum. The donation is 20%. So if you look at the calculation that I did there on the slide, so how we calculate is we've foregone the interest, so it's your loan multiplied by your official rate. That gives you your actual interest paid. So it's R1 million times 10%. It's 100,000 rand. So it is deemed that your donation for the first year is 100,000 rand. But the second step, then you calculate then your donation tax. So you take the 100,000 of which from step 1 and you multiply it by 20%, which is your donation tax, which gives you 20,000 rand. So the result at the end of the day is Mr. X must pay 20,000 rand donation tax for the year on the interest-free loan. Does that answer your question, Marco?
Yeah, indeed.
Right, good.
It seems that having a trust or incorporating a trust or operating with trusts,
Yes.
Trusts in South Africa is quite more expensive than.
Yes, it is.
than in
No,
Italy.
it is.
So it seems to me.
Used in the past.
Yeah, okay, so it's a kind of a reaction of.
It's a reaction. That's why it's constantly evolving. And that's why we have our constitutional court, which is extremely active
Okay.
and looking at, but we will look at 1 or 2 cases maybe a bit later on, just to see how the constitutional court has basically got involved, looking at equality and those
Sure.
responsibilities.
I don't know if you have ever addressed this point, but sometime we need to, we will look at South Africa, but we look at the other former UK colonies like Australia, New Zealand, Canada. But is this direction like unique of South Africa, or according to your knowledge, do you think that also the other countries like Australia are reacting in the same way to the abuse of trusts? Or
I think they are, but I think South Africa's got a very prolific constitution.
okay,
So equality, dignity, and freedom is something that is, those are the founding core values of our constitution. And that is why the Constitutional Court has to get involved and make these decisions, especially when it comes to equality. Like you will see shortly now with the polygamous marriages, where
yes, I'm sure.
to step into the arena and say, but hold on, this is not fair. It's inequality. For example, in the past, but I'm not preempting, but in the past, in terms of your customary law, if you're a woman, you are not allowed to inherit, only being inherited.
Okay.
So the Constitutional Court had to get involved and say, this is inequality. We can't allow that. And they had to change the legislation. So the Black Administrative Act had to change.
But that prohibition to inherit, but we'll see that later, maybe.
Yeah.
It comes from customary law of the tribes, or?
It was from the tribes. So it's your indigenous people.
Indigenous.
And to answer your question, Mark, I think if you look at Australia with your Aborigines,
Mhm.
if you look at Canada with your Red Indians, I'll refer to them as your Red Indians, and also in New Zealand, I think they probably have similar kind of situations that we have in South Africa. Whether their constitution is as prolific as the South African Constitution and as democratic as our South African Constitution is a question maybe for another day and possibly a nice topic to look at.
Absolutely.
But in terms of South African law, most certainly our constitution is very active, or constitutional court is very active in forcing promulgation of legislation.
So in your opinion, more active than the Australian and New Zealandese Supreme Court, maybe?
100% sure, but
Sure.
we can look.
Probably,
But
for sure, yours is.
Ours is very proactive for this. About a few months ago, in fact, we had a very interesting change in terms of constitutional law related to family law. not necessarily tax implication though, but it dealt with redistribution of wealth. If you, in terms of your marital regime, if you're married in or out of community of property, and so before the Matrimonial Property Act came into operation. And the Constitutional Court made a ruling says is inequality. And they basically, in terms of our constitutional rulings, what they often do, like also with regards to our Divorce Act, sorry, not a Divorce Act, our Marriage Act, they gave a 2-year, 24 months or 12 months sometimes, period in which to remedy the defective legislation.
Okay.
So, for example, in family law, we had the Marriage Act that said only heterosexual people can get married. We had a lot of people that said, well, fine, let's just amend the Marriage Act to allow for same-sex partners to get married as well. There was a lot of Christian and religious opposition to it. So what they did is they had to promulgate legislation to rectify that. And that is how we came with a third piece of legislation regulating our marriages, which is the Civil Union Act, which now you have your Marriage Act that regulates heterosexual marriages,
Okay.
monogamous, one man, one woman. You have your Civil Union Act, which basically deals with monogamous, heterosexual, and same-sex marriages.
Second layer, like tiramisu.
Tiramisu, the cream, is we've got the recognition of customary marriages, which regulates monogamous and polygamous, heterosexual and homosexual, in other words, monogamous marriages. So we've got 3 pieces of legislation.
My goodness.
And in between that, we have our religious marriages, our Muslim marriages, our Islamic,
So, of course,
our
which are recognized by
Hindu
the.
marriages. Muslim marriages are now recognized, yes, but they fall under the Marriage Act.
Okay, so the first layer. Mhm.
But your Hindu marriages, we're still working on it.
Okay,
So it's complex, but it's constantly evolving. We
absolutely.
are a very diverse society.
Sure.
And
That's
it's
it.
always exciting because it changes constantly, which I hope you realize.
It's fascinating.
Been in the profession for a while, but with the youngsters, I hope you enjoy the evolution of legislation. It's not dull at all.
Absolutely, absolutely. Okay, sure.
Continue. So we slide 8. So capital gains tax, Marco, is something that came into operation. So I don't know if you have something similar to capital gains tax in Italy.
Yeah, we tax capital gains upon realization.
So basically on death, I'm specifically looking at it now from an inheritance point of view. An individual's capital gains are deemed disposed at market value. All right, that's the first thing. But the first 300,000 of the gain is excluded from capital gains tax. And that is in terms of our Income Tax Act, Section 26. However, capital gains tax combined with estate duty may result in significant tax liabilities and effectively constituting double taxation. So again, as example for you, slide 9. If you have a family home, for example, with 5 million rand in capital gains, it's transferred to a non-spousal heir.
Mhm.
The estate must pay capital gains tax on this gain in addition to estate duty on the value. So executors, again, must plan for liquidity and ensure that assets can be settled without disrupting family continuity. And I think this is what we are looking at, double taxation. So let's quickly touch on the indigenous succession. I know we are running a bit short on time, but I'm going to quickly just touch on 1 or 2 things. Historically, we had the Black Administration Act, which basically dealt with male, and the terminology that was used was primogenity. And it prevailed in African customary law mostly, where widows and children were often excluded. In 2005, so about 20 years ago, we had a landmark case which is referred to as B versus Magistrate of Kanyelicha. And this is where the Constitutional Court basically came and said, hold on, this is inequality. And it declares this unconstitutional, declaring it that it is a violation of your right to equality and your right to dignity, as guaranteed by our Constitution. So this led to the Customary Law of Succession Act, 2009, that had to align with the Interstate Succession Act of South Africa. So currently, our widows and children can inherit, but customary practices regarding family leadership remain influential. So customary law is quite dynamic. This is what I touched on earlier.
Mhm.
It involves with communities. Wealth and customary contexts often represent family responsibility rather than individual ownership. And this is the concept of Ubuntu, Marco, that we wrote about.
Right.
Ubuntu, you look after your brotherhood, in other words. Succession is about transferring responsibility for family welfare, in other words. For instance, even if inheritance laws provide equal division among children, the eldest son may still be responsible to manage the family property. And I think it's similar in Italy, is it not?
We have some, I would say, some portion of the inheritance which must be reserved
Yeah.
to the parents, or
Okay.
not the parents, sorry, to the spouse or the conjugal. I'm missing the word.
Yeah, husband or wife,
Yeah,
or
wife.
children as well.
And you can't basically escape
Yes,
granting
it's not.
a certain amount to those persons.
Yeah. But your responsibility in managing your wealth, does it fall with the elder son?
Well, I wouldn't say so.
No.
I wouldn't say
Okay.
so. Not at all.
So that's then very different. So especially with our indigenous law, it vests with the elder son.
Oh.
So he takes control of the responsibilities of the
Oh
estate.
my.
Not necessarily assets, but the responsibility. He
Okay.
must look after
Even tax responsibility in case of failure of
It is-
evading taxes or
it
anything.
is a responsibility. So wealth planners again must respect equality under the Constitution, while also acknowledging communal norms and customs. So, like you can see, it's a bit of a minefield out there when it comes to South African wealth transfer. Marco, you touched on trusts. So, yeah, South Africa has trusts. It's regulated by a common law system. Key statutes addressing specific aspects, particularly taxation and administration. In terms of your common law, it provides for general principles on creation, duties, and obligation of trusts and the trust beneficiaries. Trusts are not heavily regulated by a single statute. So we've got the Trust Property Control Act as well as the Income Tax Act. Those are our two central pieces of legislation. Trusts are the possibly most popular vehicle for asset protection and intergenerational planning. Like in the case of Italy, I believe. They provide flexibility, shielding of assets from creditors, and allow controlled distribution over time. However, like I've indicated in the beginning, it has certain existent risks, for example, your sham trusts, and can be challenged. So Section 7C, which we discussed earlier, ensures that, for example, your low interest loans or trusts are taxable. Key cases in this, a case that's quite interesting to read, in fact, is the Tristle Trust case. It's a 2024 case. I can give you the citation later on if you want it, which limited the conjoint principle. And the Constitutional Court again in 2025 clarified trustees' decision-making obligations. So you can see the influence of the Constitutional Court continuously.
It's very.
I'm not going to give a major discussion on the Tristle Trust case. Just to say to you that it basically dealt with the introduction of potential double taxation. Tax planners again must reassess laid trust arrangements to ensure compliance. Just the implication of the case, I think, is important. So you are looking at first-tier trust. The implication of this ruling basically resulted in paying capital gains tax on income tax on the gain that it realizes in the first-tier trust. And then on your second-tier trust, it also looked at the gain. If the gain is again distributed, that gain may also be taxed. Because of the conjoint principle, which cannot be shielded. So your result, in other words, of that decision of the Constitutional Court is that without careful structuring, the same gain or income could be taxed twice. Double taxation, double taxation principle. Let's just move on quickly to slide 13 then, trust decision making. I've touched on this as well about the sham trust that one needs to look at. Trustee often faces uncertainty over decision-making authority. And again, the Constitutional Court clarified this and it deemed a trust to be specified majority decision-making with a quorum and notice requirements. So these decisions makes the trustees binding. So absence of such clarity basically is regarded as a sham trust. So it's a trust that exists from, but not in substance.
Yes.
And
formally,
so it's defined as a sham trust. It's defined as a trust that exists in form but not in substance. So, technically speaking, you retain control over your trust assets, and that's why I say a lot of people actually abuse the system, unfortunately. So your key risk is if control is not genuinely separate between the seller and the trustees, the trust can be ignored for legal and tax purposes. SARS or the courts may treat trusts assets as part of the seller's estate for donation tax, estate duty tax, or capital gains tax, in other words. I'm not going to deal with the requirements for a genuine taxation. I would like to move to slide 14, Marco, just to look at the wills and freedom of testation, which is something which is a little bit different as well from your Italian system, as I picked up with my bit of research I did. So the Wills Act of 1953 basically enshrines freedom of testation, but subject to constitutional limits, obviously, notably non-discrimination. So testamentary trusts are tools for protecting minors and vulnerable heirs, which touched on your introduction, Marco. For example, a parent excluding daughters in favor of sons may face constitutional challenges. And it has happened, believe me. There's one currently that will be discussed shortly. So regular review of wills is critical, especially in the context of changing family circumstances. Moving to the next slide quickly, life insurance and retirement funds. I don't know how your country deals with life insurance and retirement funds, but they are included in the estate and therefore subject to estate duty. Retirement funds are governed by Section 37C, which prioritizes dependence over the nomination form. And this is something that we're going to be looking at now. I don't know if you're aware of one of our ministers that passed away recently, David Mabuza. You know about it?
It sounds to me, it rings a bell, but
David
he was involved in some sort of.
It's not the one that just was found in France. It's not that one. Thinking of that one?
Yeah, not another one.
No. But David Mabuza, basically, his daughter has taken this matter to the court. So what we're looking at is when you have life insurance, you usually have a dependency form and you nominate your beneficiaries. But the administrator of a life insurance policy use that as a guideline, as a wish list, and not necessarily as a specific order in which to bestow the inheritance. So, for example, a deceased may nominate a brother, but the funds must allocate to dependent children and widow. I think that is where it's similar to your Italian system. So awareness of this discretion, again, is crucial to avoid dispute and litigation. David Mabuza case, it highlights the intersection of pension fund law, customary law, and family disputes. So it's the current case is a 44.7 million rand pension / an annuity, which was frozen due to competing claims. So the issue here, it included recognition of a customary marriage, children from multiple relationships, and trustees' discretion under Section 37C. The lesson of this case, again, is clear, as precise documentation and clarity of family and trust arrangements are critical to prevent litigation. Because you must remember here, like in Italy, yes, the spouse receives, but in South Africa, in indigenous law, there's maybe more than one spouse.
Okay.
In terms of polygamous marriage.
And yeah, not the equal shares, of course.
Yeah, that's it. The problem, however, or not the problem, but the situation now in South Africa, usually recognition of customary marriages must be registered.
Okay.
Because it's not a civil marriage. It's an indigenous custom. So the provision now is that you must register your.
There must be evidence of the
evidence. The problem is a lot of people don't go and register it.
Okay.
So now what happened in this case, I think it's in this case, they basically went and they got a certificate after the fact.
Okay.
So it becomes quite complicated.
In terms of, I don't know if you have data, but in terms of numbers, how often do you have indigenous marriage?
Often. Majority of your indigenous people still get married in terms of customary law because it's a very strong custom. It's a strong principle, and there's a huge amount that goes beforehand. In terms of expenses, there's different processes that takes place. There is the negotiation of lobola, which is basically providing cows as an act of good faith. Now, cow is about, I'm speaking under correction, I'm not an agriculturist, but between 11 and 20,000 rand a cow. So depending on the status of the family will negotiate with each other.
Sure,
what is the value of your daughter?
Yeah, but how often does it happen? Like 5% of the marriages, 4% of the marriages?
I would say
1-digit number.
70 to 75% of marriages still. Customary marriages.
But how many customary marriages are there?
Well, Mark, if you look at our population in South Africa, this is what we are 80% African, I would say.
So, out of which, how many do follow the custom? I believe that all.
Mark, I would say, I don't know.
Roughly speaking, I mean, I don't want the exact numbers.
I would say probably the majority of them still partake in customary marriages. What has happened subsequently is a lot of African um, South Africans would, for example, enter into a customary marriage and then do the official civil marriage as well. But again, in terms of legislation, when you enter into civil marriage and you want to enter into a customary marriage, you have to actually record it. You have to recognize.
Sure. Well,
And with polygamous marriages, it's like a Muslim marriage. The second wife actually, or the first wife actually needs to agree, give a
yeah, sure, of course,
to
the approval.
a subsequent marriage. Yes.
So yeah, you said 80% of the population is native. Of course, I know
Yes,
that, but
yes.
out of this 80%, roughly speaking, like
How many?
50% of these, which means around
At least-
40%,
At least 50%.
are, my goodness.
I was looking for the statistics actually. It's a very relevant point.
I
But
wa- I
I would
was
say
think-
at least 50%.
I was thinking about the tiny minority, like 2-3%, 5%.
No,
More than that, definitely more
no,
than that.
it's the African people are very proud people, and it's fantastic because they have these very unique cultural experiences, norms, traditions, patriarchal systems, which are still very much alive.
Impressive.
Yeah. All right.
Okay, so
Compliance and governance, I don't know if I need to really relate to that, but the regulatory landscape is tightening, where you have SARS, you've got the Master's Office, the scrutinized states and trusts, independent trustees, you've got the Constitutional Court that actually oversees everything. So let's move to slide 18 quickly, which is the wealth tax debate. This is quite an interesting thing going forward, as in South Africa, there is this ongoing policy debate about introducing a net wealth tax. I think you guys are looking at something similar.
yeah, there's an ongoing debate.
Yeah, the proponents argue it reduces inequality and increases revenue. The opponents' side's valuation challenges. How you're going to put value to these assets, potential capital fights, and then also the discouragement of investment. Obviously, that's a big implication. So there's no implementation yet exists, but families and advisors should anticipate potential impact and remain flexible in terms of planning strategies. Mark, I've removed some of my slides, but I think in terms of summary and conclusion, that's just basically recapping what I've discussed. And then if we move on, there's quite a nice comparative analysis from South Africa and Italy. You should be able to look at the comparatives just in terms of capital gains tax, donation tax, etc., which is basically what we've spoken about. But I thought
it's a summary for Francesco, Anna, the others are following, all the data.
look at that.
So thank you very much.
And that basically concludes my presentation. Thank you.
Thanks a lot. Thank you, Lizelle, for the information you shared with us, a brand new perspective on South Africa. And, we discovered a lot of things, and maybe now Alessandro can share his description, his views, his findings on the Italian tax system in the matter.
Yeah.
So, Alessandro.
Thank you, Professor. Thank you, Professor.
Thank you
Thank you very much. Basically, I found a lot of similarities between the general framework and our legal system, not in terms, of course, of substance, I would say. Of course, your legal order, I would say it's much more complicated somehow. Our legislation basically is structure is developed, built on the Italian Civil Code, okay, which is basically the main code enabling us to grant and to regulate the relationship between spouses in the family, regulating the obligation between the husband and wife, and between the parents and the children. And in terms of protection of the family wealth, I would say I chose two main institutions, which are the Family Trust Fund and the Family Pact. So starting with the Family Trust Fund, there are some similarities indeed with the fund and you described in South African legal system, but yeah, indeed, your fund is much more expensive than ours. I would say that our fund can be tax-free somehow, and the topic, the main element in this scenario is the one that Professor Gregi was describing. Our legal system taxes the fund and the constraint upon the goods only when there is a transfer of ownership which occurs between the two spouses. I would say, I make an example just to make myself clear. If I'm the owner of a real estate, of property, of a house or whatever, and I'm the full owner, I own the 100% of the property right upon that good, and I put that good, that asset, within the family trust fund, then in that case, without reserving myself the property upon that good after the termination of the fund, then in that specific scenario, the property, the property right is somehow shifts. It shifts, of course, toward the other spouse.
Yeah.
In that case, the tax legislator assumes that there is a transfer of the right of property, of course. So there is basically the one receiving the half of the property right gets richer, of course, from that operation. So the legislator presumes that that operation, that choice, is proving an ability to pay upon the one providing the operation. In that case, of course, the legislator will tax.
Yeah.
The
Because I will, sorry to interject.
Yeah, sure.
With us, it's the estate that gets taxed.
the state gets taxed.
The estate.
Oh, sure,
The
sure.
business estate gets taxed. With you, as I understand it, the beneficiary gets taxed.
No, no. It's like, for example, if the two of us were somehow in a hypothetical scenario, allocating a good and making a bond in terms of destination of income arising from that good in the future. In that case, if I'm the owner and I do not reserve the property upon that good,
Yes.
upon the transfer,
Yes.
then since I'm splitting
Yes.
the property right over the good, upon the good, the transfer, the operation overall is subject to tax, and it must be, it's an indirect tax called the registered tax, and it will be, no, it's a donation tax, inheritance and donation tax, I would say.
Case of a separate attribution, yeah.
Yeah,
But
inheritance and donation tax. Yeah,
the calculation, the name is different in Zell, but the rates are roughly speaking
Yeah.
pretty much the same. Yes.
exactly. Because it's like a symptom, an index of ability to pay
Okay.
upon the one building basically the.
Okay.
And that's pretty interesting. Whether at the opposite,
Yes.
if I decided to reserve the property over the good, so at the end of the fund, the property right over the good will return fully on my legal sphere. In that case, since there is no transfer of the right,
Yeah.
I will be tax free, or I will just be burdened with a 200 euro tax. So it's pretty interesting.
Yes.
I don't know how much time do I have, like.
Well, maybe a couple of minutes.
Okay.
We have to leave the room. actually.
So basically, yeah, this is the very first comparison, I would say. Another huge difference in our legal orders is, of course, the freedom in the capacity testament to make the wills, basically, to transfer the goods mortis causa, we say. So after our death, if I understood it correctly, you have full freedom, or
It's full freedom.
basically full freedom. We are at the opposite, I would say, bound, and there are strict limitations upon the one making the last will, the testament. So this is pretty relevant for our second institution, which is the Family Pact, which is something pretty interesting. I didn't understand actually if you have the same or something similar. In Italy, for and we want to say at the very same time, there is the Family Pact as the purpose to say, to protect the business, basically, the business of the enterprise, of course. So we want to save that good. At the same time, we must protect, for the very reason I just mentioned, we want to protect the fairness and the relationship between the heirs,
Yeah,
the beneficiaries,
Yeah.
the tenant. So
Like a succession plan.
exactly. So the legislator basically structured this compromise which is aimed to save to save and to protect at the same time the business continuity and the portion which are due, and they can't be this freely alienated. They can't just be dismissal like in your cases. So the family pact is basically a contract which must follow the highest requirements in terms of form. We must basically draft it in front of notarial,
Remains
which is
yeah,
which is basically exactly. And
so it gets registered.
exactly,
Mhm.
exactly. So
There's evidence.
exactly, pretty expensive.
But
The
it's
draft,
transparent.
it's absolutely transparent.
You
I
don't
think,
have any family fights
yeah,
afterwards.
I think it's
Under the sun.
yeah, and two witnesses must be
Yeah, in theory, yeah.
yeah.
In
It's
practice,
the paper, yeah.
Yeah.
It's on the paper. Two witnesses should basically be in the same place and to in order to prove the contract. And in that moment, basically, what actually happens is that the effects, the legal effects of the succession are basically anticipated.
Okay.
So you have a distortion, a temporal distortion, and basically the business ownership shifts on the legal sphere, on the disposal of the beneficiary, which is an heir, of course, of the deceased, of the man granting basically the business ownership, and in the very same time, the heirs who are excluded from the contract, they must receive, I would say, a compensatory liquidation somehow, a sum of money,
Like a compensation.
exactly, compensation, compensation, in order to protect, as I said, of course, the rights
Yes.
of the heirs and the business continuity.
So even if you offend your mother or father, they still have an obligation to let you inherit.
yeah.
Yeah.
There are only a few,
Sure.
there are some conditions on the law of indignity to inherit. If just to kill them or have committed very serious crime, I mean, inferior offense.
Yeah.
Well, yeah, so there are conditions, but
Okay.
really important.
Very strict.
So your system is very similar to our intestate succession in South Africa.
Mm,
Intestate, you don't have a will, in other words, it goes to the spouse and the children
I see.
in child portions.
Mm.
So similar to what you have in
Yeah.
UK. But with us, yes, intestate succession, you can decide.
Mm.
You can give all your money to the SPCA if you want to.
So there's always a limit that, as Alessandro pointed out,
Yeah.
must be given. Must be given absolutely. No way. Yeah, really are free. Of course you are, but you have a leeway.
Yes.
Like depending on how much are you free? I mean, well, what is your freedom? It depends. If you only dispose 50%, dispose in children's, some several children's, they vary according to your family status.
Yeah. Okay.
And in terms of taxation, the family pact is basically, I would say, health. There is a tax exemption which is very, I would say, which points out the aim of the family pact itself. Because without the exemption, the pact is taxed, of course, and it will be taxed it will be taxed twice actually. The very first operation, so the very first disposal of the business in the head upon the beneficiary will be taxed with the inheritance and gift taxation. At the same time, the compensation that the beneficiary must provide to the heirs who are excluded from the business ownership will be taxed again, unless the exemption applies. But of course, the exemption has some serious requirements. For example, the beneficiary must commit himself to keep the business going for at least 5 years later receiving it. He must basically he must take care of the business after receiving it. So in that case, the tax exemption will help the beneficiary under the condition that the business is preserved, under the condition that the aim of the exemption is met. So I think that clearly here you can see the purpose of the family pact, the difficulties who face it in basically finding a balance between the heirs who are excluded from the business, from the management of the business after the death or basically the contract, the signature of the contract, and the heirs who is entitled and who is basically somehow responsible and liable for the continuation of.
And the heirs, in your case, is not necessarily the eldest child.
No, not necessarily. Not
But what's quite clear is there's also to some extent, a responsibility that passes, like with the interstate, with the indigenous law. They're not only transferring the wealth, they're also transferring the responsibility to look after the family. So somehow,
assets and liabilities together.
you actually also transferring that responsibility to keep the business going.
Sure.
So that's fantastic. Margaret, just to answer you, sorry, are you?
No, yeah, of course. But I will conclude just by saying that, but of course, we have actually a criminal provision and a criminal rule, which is applicable to those who basically create a fake family fund. You were referring to those.
The sham.
Yeah.
The sham.
In Italy, if you basically avoid taxes for an amount equal or exceeding 500,000 euros, and of course there is case law which provides us the guideline in order to determine whether or not the one creating the fund created it to avoid taxes. So it's not always that it finds it. Yeah, exactly. For example, if you just create a fund which is disproportionately big or valuable, worthy in comparison with the family needs, or I don't know whenever you have a tax procedure which is open, and most likely we receive a tax.
Audit.
Yeah, tax audit. And just before receiving it, you just create the fund. This
it is quite clear.
Exactly. Yes. Or, for example, whenever you just create a fund and then you put just your car in it, and of course the fact that you put your car in the fund, in family fund, is just inconsistent with the purpose of the rule, because the fund should be aimed to generate income, to be bound for the family needs. So if you just put your car in,
so it's abusing the system.
Yeah, abusing the system.
Similar to South Africa.
Yeah.
We have a very similar understanding of those.
Margaret, just to answer your question quickly,
Mhm.
I quickly Googled it. So in 2022, in terms of customary marriages registered in South Africa, 4,376 customary marriages, which is a significant 63.5% increase from 2021. Increase. So according to Stats South Africa. So results show higher registration rates.
That's impressive.
Yeah, so it's definitely, it's not something that's falling by the wayside. It's something that is actually still taking place.
Yeah, I thought it was something like fading out or disappearing slowly, like most of the tradition. It's alive.
It's about
Okay, so that's it, right, Alessandro?
Yeah, I think
Fine. Yeah, our time is over now. Thank you very much, Lizelle, for your presentation, and Alessandro for sharing with us the Italian perspective on the matter. Thank you to my other PhD students and the other people attending for being with us today. The seminar now is over, but it will be available on our website in the next days. All the best. See you.
Thank you. Thanks, Margaret.
Okay, and that's it.
Lovely.
Stopping the event.